Welcome, everyone. I'm Deborah Rohde, Director of the Center on the Legal Profession, and I want to welcome you to this event. Not that there's anything to talk about with respect to gender these days, but just in case. Thanks to Jason Solomon, the Executive Director of the Center, for his hard work in setting this up. And most of all, thanks to David Sanford. He is the chair and co-founder of Sanford Heisler, who's recovered more than $1 billion for individual clients in the U.S. government since 2004. He served as the lead counsel in more than 50 class actions, represented more than 100 attorneys in discrimination cases in various contract and employment matters. He's widely recognized as the leading national litigator in the struggle for gender equity in the legal profession. He's also, I'm so proud to say, a graduate of our law school and a highly valued supporter of the Center on the Legal Profession and a member of its advisory forum. On a personal note, I'll just disclose that I've worked with David as an expert witness in 3 successful gender cases and have the utmost respect for his abilities and his commitment. His recent victories include a $14 million class action settlement on behalf of women surreptitiously videotaped while performing a religious cleansing ritual, a $4 million gender discrimination case on behalf of female members of the Forest Laboratories National Sales Force, and a $1.25 million jury verdict against Columbia University in a sex harassment and discrimination case on which I worked. He's the lead counsel currently representing more than 15 female partners at big law firms throughout America. And on behalf of 3 female partners, he recently settled a case alleging gender discrimination and pay equity against Chadburn and Park, now Norton, Rose, and Fulbright. He also recently settled a gender discrimination matter against Proskauer, and for his leadership on these issues, he's a finalist for the American Lawyers 2018 Attorney of the Year Award. David, I know you're a busy guy, so thank you so much for making time for this.
Thank you. Can everyone hear me? Yeah. Thank you, Professor Rohde. Appreciate being here. I always love coming back to Stanford. I graduated in 1995, and I have great memories. It was 3 of the very best years of my life, and I say that all the time, and it's true, and I hope that's true for you as well. I've worked with Professor Rohde, as she has said, on a number of cases. She has provided indispensable support as an expert witness in a number of our cases, and her brilliance and her ability to recount extraordinary detail over the lifetime of a case condensed into a 7-hour deposition is truly a sight to behold. And I had that privilege of defending Professor Rohde in a deposition not so long ago here in this area on a case that we worked on, and I appreciate everything that you've done, so thank you for that. Professor Rohde asked me to come and give some remarks for about 20 minutes, which I'll do. I don't really have anything super prepared, but I did jot down a few notes in my car on the way down from San Francisco this morning, so I'll rely on those notes as I think through the issues, and I'm happy to answer any questions you have at the end of my 20-minute presentation. Harvey Weinstein. That's really all you need to know when you think about where we are today with respect to gender discrimination in this country. Harvey Weinstein matter broke about a year ago, and I can tell you from a firm perspective, I got a call recently from someone from the American Lawyer asking me why it is that there is so much activity with respect to gender discrimination cases in law firms. And we talked about that, and I reflected on the cultural moment we're in, and I thought about the level of activity we've had in our firm. So I'll share with you an anecdote about that. We have now, Cody Coho is a former legal assistant, did outstanding work for us up until a few months ago. He's a first-year law student here. And he was one of about 35, and we have about 35 now, legal assistants nationwide in 6 cities. And we keep track of how many people contact us and do intakes over the phone. And last year, we logged in a little over 2,000 intakes, and we accepted about 4% of those cases. So we accepted about 80 cases out of the 2,000. This year, 1 year after Harvey Weinstein, we are on track to double that number to approximately 4,000. We'll accept about 4% again, so we're on track to accept about 160 cases. The vast majority of people who call us regarding some aspect of gender discrimination. What we're experiencing now is really a tectonic shift in our culture, having to do with women feeling comfortable and being emboldened to come forward, as Dr. Ford did recently before an international audience, talking painfully about her experiences many years ago. In an academic context, we see a lot of people coming forward. As Professor Rohde mentioned, we had a trial that went forward on behalf of a business school professor at Columbia this past summer. In addition, we represent 5 students at Dartmouth University in a sexual harassment case against 3 psychology professors who have since been fired, as I understand it. We represented graduate students at Columbia, 1 graduate student, this is a public matter, in the classics department, who was forced into a sexual relationship with a mentor, a famous classicist who has since been fired after we filed our case. We have represented a rape victim at St. Paul's, a private high school. We represent a graduate student currently at NYU. The list goes on and on in the academic context. But beyond the academy, we also represent actresses in Hollywood, C-suite executives throughout the country, women in manufacturing, pharmaceutical sales. We just resolved a class action gender discrimination case against Merck Pharmaceuticals. The biotech industry, the financial services industry. We have an ongoing class action gender discrimination case against KPMG, which we filed about 6 years ago, and the class certification papers are under consideration by the court in the Southern District. In the sports area, we got the 2nd largest verdict in U.S. history last year on behalf of the coach of San Diego State University, who was illegally terminated. But the question that I was asked to address is what is happening in the law with respect to gender discrimination. And here's what I'd say about that. Law is big business. It's subject to the same forces and pressures felt in corporate America. It's subject to the same ego conflicts, the same psychological dramas, the same financial issues, and the same striving for success that we see in the rest of corporate America. So it should come as no surprise to anyone that the law is also subject to rampant gender discrimination in pay and promotion, subject to similar sexual harassment issues, and subject to the same pregnancy discrimination cases that we see in corporate America. We currently, for example, represent women associates, female associates at Morrison & Foster. When I was here at Stanford in the 90s, Morrison & Foster was viewed as the preeminent law firm. If you got a job there, you really made it. And I think that's still viewed generally today. It has a great reputation as being a firm associated with pro bono matters, progressive causes, and good policies within the firm. But it came to our attention not so long ago that they also have a problem. And the problem goes like this. They hire female associates. Female associates sometimes get pregnant and go out on pregnancy leave. When they go out on pregnancy leave, they avail themselves of statutorily protected rights, come back from pregnancy leave, and what happens? To the vast majority of people that we are aware of, and there have been some exceptions, but to the vast majority of people, they are held back a class. So if you go out, as one of our clients did, as an 8th-year associate, fully expecting to come up for partnership in her 9th or 10th year, she comes back, and unbeknownst to her, she was held back a year. And the way she found that out was looking on the electronic portal in the firm, and then raised questions about it. And once she did, a number of other women also spoke with her and realized that they were subjected to the same practice. And as a result of that, we now represent them in a class action on behalf of all female attorneys who are subject to that practice. And the exceptions are unclear why there would be exceptions, but it's my belief that if you have a strong, powerful mentor who happens to protect you in the right ways, you may not be subject to that practice. But that case is ongoing and going into mediation. Some statistics. Female attorneys, and this is according to the Major Lindsay in Africa report published in 2016. Female attorneys comprise about 45% of law firm associates, but there are only 18% of equity partners who are female. And that represents an increase of 2 percentage points from 2006. So over the course of a decade, it increased from 16% to 18% female equity attorneys. In addition, there's a 44% pay gap between female and male partners. Female partners averaged, according to this survey, $659,000 a year, whereas male partners averaged $949,000. Currently, we have cases relating to pay and promotion discrimination against firms like Ogletree, the Mofo case that I mentioned, Jones Day. We've had cases against Chadbourne Park, Proskauer, Sedgwick, Howery and Simon. The list goes on. And we currently represent over 20 female partners in AmLaw 100 firms with similar claims. And those partners are not all non-equity partners. Many of them are equity partners. And those equity partners are often in otherwise positions of power. We're talking about a chairwoman of a major firm that we recently represented. The head of litigation of a major international firm we recently represented. The co-president of a firm we recently represented. The co-chair of the employment practice of a national firm we recently represented. So these are not just associates or non-equity partners. We're talking about women who have made it seemingly to the very top, only to be thwarted in various ways because they're not able to get the kind of information that male partners routinely have access to. They're not paid in similar ways, and they're not giving the kind of privileges and perks associated with that position typically expected in this country, expected by male partners. Most of the cases that we take on a pre-suit basis. That is, we send a demand letter to the other side. We invite the other side to have a conversation, typically leading to a one-day mediation with the third-party neutral who helps us resolve the conflict. In about 80% of our cases, we're successful. You'll never hear about us then. We take the case, we take it through mediation, we write a mediation brief. Great legal assistants, again, like Cody, are very instrumental in that process. All the way through mediation. And then we resolve the case if we're lucky. If we're not, in about 20% of the cases we're not successful, we file, and that's when you hear about us. But again, the vast majority of cases are done confidentially and rather quickly. What do those cases have in common? As I was driving down from San Francisco this morning, I was thinking about that because I didn't want to talk about case-by-case issues. That would be too involved and, quite frankly, somewhat boring. But perhaps I could synthesize what I think those cases, by and large, have in common. Compensation decisions are routinely made by one man in a firm or a small group of male partners. Compensation is often tied to what's called partnership points, points allocated typically by one man or a small group of men. The points themselves are tied to anticipated revenues. Typically what happens is that one man or a small group of men overvalue the anticipated contributions of male partners. Management committees rarely increase the point total significantly over time, and therefore, once the point totals are assigned as you begin your tenure with a firm, that point total sets the disparity for the rest of a person's tenure with the firm. So, for example, in one of the cases that we litigated, you had point totals ranging up to 2250 assigned to male partners. The top point total assigned to a female was 1,000, more than double for men as the range. So that discriminatory point allocation system in part is related to the discriminatory origination credit system. So if I'm a partner in a firm and I bring in IBM, I get a certain percentage of all the revenue for the firm associated with that case. It could be 10%, it could be 20%, it could be 30%. And the origination credit issue is a big one for most people because it's not typically so clear that I brought in the case. You have a big company like IBM, not surprisingly, you'll have a lot of people with connections to IBM. And so the question is, how much origination credit should I get versus my colleagues, male and female? Who decides? One man, typically in a firm, or a small group of men decide that origination credit, and that is typically done on a discretionary and secretive basis, which leaves you very little room to challenge the origination credit. Not surprisingly, the origination credit falls primarily to male partners. Firms often allow departing partners to hand-select other partners to receive credit for their client matters as billing partners. So if I retire or if I become ill and decide to leave the firm, I, as the billing partner with the origination credit, have complete discretion in many of these firms to hand off that origination credit to another friend. And that, not surprisingly, is typically someone who looks a lot like me. That system of origination credit and transfer continues and exacerbates the overcompensation to male partners and the undercompensation to female partners. Associates typically suffer a different fate. Often in these firms you have a lockstep compensation practice, so you don't have the kind of pay disparities that we note in the partnership ranks. But there often are pay disparities with respect to bonuses. And if you look at the major Lindsay in Africa study in 2016, which I strongly recommend everyone do if you're thinking about entering big law, you'll note that they chronicle in a 2-year period from 2014, January 2014 to December 2015, in the litigation department of one firm, you had 20 non-partner attorneys who left, 17 of whom were female. In one case, you had a 115-year-old firm that never had a female on its management committee. Not until, that is, we filed a lawsuit a couple of years ago, shortly after which they found the grace to put one female partner on that committee. Generally as well, you see a black box system in place where there's no transparency, no equal flow of information. In some cases, partners are in fact discouraged or forbidden from disclosing their compensation. So important firm decisions are often made in secrecy, including decisions to open new offices, hire or fire new partners, decisions regarding mergers with other firms. And that wall of silence is a significant role that reinforces the glass ceiling by shielding management from oversight and giving it unchecked dominion over the compensation and employment of firm partners. So there are legal challenges that we face when we bring these cases. It's not easy. There are a lot of important threshold issues. I'll just mention one. We bring cases under federal statutes, among other statutes. We also bring cases under state statutes and common law. But the federal statutes that we typically apply or seek to apply are Title VII and the Equal Pay Act. And the threshold legal issue for us in those cases is whether or not the people we seek to represent, namely often partners, are employees for purposes of the statute. And whether an individual is a covered employee turns on the question of common law of agency issues and where you look at the totality of the circumstances relating to the parties' relationship. You look at a firm's control over the plaintiff's employment. And the Supreme Court in the Clackamas case, a Supreme Court decision in 2003, articulated 6 factors that drive the inquiry. And it's those 6 factors that we fight an awful lot about. And that fight takes typically an entire year to resolve, because we fight about the nature of discovery, we fight about the scope of discovery. Once we get some discovery, we have to file motions to compel further discovery, because it's a fact-intensive inquiry that really makes a difference. And it makes a difference because of the Clackamas case that articulated these 6 factors. 1, does each partner participate in hiring and firing? Does each set the rules and regulations for the work? 2, the extent to which the firm supervises an individual's work. 3, does the partner report to someone higher at the firm? 4, the extent to which the individual partner is able to influence the firm. 5, whether parties intended the partner to be an employee. 6, whether the individual shares in the profits, losses, and liabilities of the firm. No single factor, the Supreme Court held, is decisive, and the 6 factors themselves are not even exhaustive, but they are the key factors that we need to get information about and ultimately argue about and ultimately be successful in arguing if we're going to be able to proceed with a Title VII and or an Equal Pay Act claim. Now, why do we think we will succeed, and why do we think we should succeed in these cases? Big firms today are multinational organizations with hundreds of partners, often in scores of offices around the world. The Clackamas Court held, and I quote, "Today there are partnerships that include hundreds of members, some of whom may well qualify as employees because control is concentrated in a small number of managing partners," exactly what we argue in our cases. We argue that the management committee controls the hiring and firing, that partners report to or are supervised by management committee members, that partners have little influence over the firm's affairs. The question of a party's intent regarding this status depends on a fact-intensive inquiry and discovery, that female partners do not share in the firm's profits and losses in a meaningful way. There aren't shares in a fixed proportion of profits and losses aligned with one's ownership interest, but rather they're awarded by committees each year on a discretionary basis, somewhat akin to receiving a bonus if you're an associate. So for all those reasons, we fight hard, but in order to win, we have to at least win that battle. And once we win that battle, we then can proceed with the merits of the case. And if it's a class action, we have to then win the class battle. And once we win the class battle, we have to win the decertification battle. And once we win the decertification battle, we have to win a trial. And once we win a trial, we have to win on appeal. The defendants only have to win one time to be successful. If a defendant wins one of those battles, it's game over for us, typically, either on the class basis or on the merits or both. So it's a very hard, long, costly, exhausting process that we engage in. But it's worthwhile. It's the process we have. And fortunately, our firm has been successful in those battles so far. There are broader societal perspectives that I'll end with and then open up to questions. From a broader societal perspective, these cases are a microcosm of what is playing out on our current social, political, race, and economic stages. It represents the concentration of wealth and power and prestige and opportunity in a small group of people in a large organization. That small group happens typically to be white and male. And not surprisingly, that small group of powerful and wealthy people do not want to relinquish power and wealth and opportunity. And when they're forced to relinquish that power due to forced retirement or illness, they hand off that power and privilege to people who look a lot like themselves. It is what we see playing out every day with President Trump and his supporters as they push forward a radical platform of immigration reform, extraordinary tax cuts for the wealthy, Federalist Society clones elevated to the federal bench, international realignments, and environmental policy focusing on short-term gains for business with the inevitable longer-term global catastrophe which is upon us. Democrats have been particularly bad at winning elections since Obamacare and the rise of the Tea Party in 2010. And in order for us to reclaim some common sense, balance, decency, and justice, 2018 and 2020 must represent a reawakening in this country. The courts, and this Supreme Court in particular, will not save us. We need to save ourselves. Thank you.
So that was really inspiring and dispiriting at the same time. So I'll just start off with one question, and then I'll let you take your own because you're good at that. One question I've so often been asked, because I specialize on gender equity issues, including ones in the profession, and a question I've often asked you as a consequence is, you know, why aren't lawyers different? You know, they do know their laws, right? So why do so many smart people make such colossally stupid decisions? Do they think no one's paying attention? Is it the process that's so unwieldy? It's the fact that until recently people weren't willing to challenge them. But that firm, for example, that you mentioned where, you know, 1,000 points was the highest any woman got, and, you know, that's half of what men got. Do they think that no one will notice that? So I'm just kind of mystified that in this current climate, there still is so much, you know, fairly obvious gender gaps that you would think the people running these institutions would realize that when half the talent pool is female, folks are going to notice.
Well, I think the short answer is one word, and that's power. They do it because they can. And they've gotten away with it, and firms have gotten away with it for a very long time. I'll give you one story, which is really an extraordinary story. There's only so much I could say because the case was ultimately resolved confidentially. But we recently represented a woman who was the chair of litigation for the entire firm. It's a firm everyone in this room would know by name. It's one of the most powerful and most generally well-respected firms in the United States, and it has an international presence. Despite being head of the litigation practice, she was grotesquely underpaid, and she didn't know it until recently. Underpaid relative to her male peers who were not, as it turns out, head of a global litigation practice. And by underpaid, I'm not talking about the level of underpayment that I talked about earlier, the average being 949 versus 667 or whatever the numbers were there, which is a tremendous difference. I'm talking about millions of dollars per year underpaid. And she didn't know it. And the firm got away with it. And they got away with it because they could. They shielded her from that information. She didn't have access to that information. She found out about that information kind of willy-nilly. And once she did, she called. And once she called, I called them, and we worked it out. And in a very good way, I must say, for that female partner. But for years, she worked her way up the ranks and did extraordinarily well to become the chair of this practice, only to realize that there was something else going on, and what was going on was determined by a very small group of males who had been and still are in power, and had been in power for many years. So I think the answer is it happens because people get away with it and they know they can. Now, with the push for transparency, it's going to be more difficult. But even if we get to the point of being transparent, where there's no more black box and there's full disclosure about where people are relative to each other, you still need to be very careful, because what happens in those metrics typically are decisions that underlie the numbers, decisions that themselves can be arbitrary and discriminatory, relying on subjective factors. If we had an objective system that everyone could recognize, that would be great. But we don't, and we're not likely to come up with it. And as a result, there's always going to be an element, and perhaps a big element, of subjectivity in the decision-making leading to these disparities. So even if there's transparency, there's no guarantee that we're going to be able to overcome discrimination. It's simply going to be harder to fight because you have to argue about subjectivity.
You take your questions.
All right. Yes.
Hi. To what extent do you think that the kind of litigation that you're bringing has an impact on similar litigation brought by women in less powerful positions, like who are not partners at law firms, but are working in other industries where they obviously face the same, if not worse, discrimination?
So when we bring a case, we typically bring it with a fair amount of fanfare. You know, we bring it with a press release, and our stories are typically reported by major papers and outlets around the country. People find out about it. And I know from anecdotal evidence, and it's not more than that, that when that happens, there's a ripple effect. And so when we file a case, often I'll hear from a former client or a friend of a former client about elevations in other firms or other industries where people are getting promoted, where they weren't expected to get promoted, or they weren't on track for that promotion at that point, where the implication is there's some causal connection. Whether there is or not, I don't know. There's no way of determining that, right? But I do believe that we make a difference that way by shining a spotlight. There are so many cases that I would ideally love to file to get the word out. The kind of case that I'm talking about now that I can't really reveal about the female partner. Because if that happened, a lot of people really would recognize that as significant, and there would be more change still. So we make change case by case, but it's very hard to, in the 70s and 80s, there used to be class actions of industry cases. So you could sue an entire industry, like the trucking industry in the South was sued for race discrimination and sued successfully. And you could do cases like that then, much more difficult to do now, really, really impossible to do. So you really have to do it case by case. Yeah.
A related question more directly on the cases. When you have these, you mentioned most of them are settled confidentially, they don't really have much beyond that. I was wondering, first of all, how often is a change in firm practice an element of the settlement that you ask for? And then second of all, how often do these cases, if they do go to trial, change substantive law? Because it seems like...
All right, so that's a great question. And the answer is it really depends on the case. So there are some cases where, for a variety of reasons, we wind up doing a confidential deal just based on money, usually because the other side is unwilling to change their practices, at least as part of the deal. Obviously, they have a vested self-interest in changing the practices because they don't want to see us again, and they figure they're going to see us again unless they change. So the kind of understanding with a wink and a nod is they're going to make changes that are significant so that they insulate themselves from future activity, but they don't want to formalize that in a document. They don't want to be held to it contractually. So we understand, again, anecdotally, that changes are made, even if those changes are not articulated as part of a memorandum of understanding or a settlement agreement. But there are cases where we have that articulation as part of a settlement. So for example, we sued Qualcomm in Southern California on a class basis for females, and we settled that case just last year when Cody was with us. And it was a great settlement financially for all of the women at Qualcomm, but also as part of that deal, and was done pre-suit confidentially, but then we filed it as a public document. So if you go Google it, you'll easily find the Qualcomm settlement and all the supporting papers, which the court had to preliminarily approve, send out notice to the class, await reaction from the class, and then have a final approval hearing and approve that. And she did approve both preliminarily and finally that settlement. It was, I think, the largest pre-suit settlement in U.S. history and had among the most extensive systemic injunctive relief provisions of any deal I'm aware of. So, you know, on the one hand, you can do individual monetary deals for a few individuals. On the other hand, you can get a deal like Qualcomm, and there is a lot of variation in between.
What about confidential, secrecy agreements? Do you bump up against that problem when you get a successful settlement, you'd like to get the word out, but condition of the settlement, non-disclosure?
So we get that all the time. But sometimes we fight back, and sometimes we fight back successfully, and sometimes we fight back unsuccessfully. So I'll give you an example of a successful fight. We brought a case on behalf, I mentioned earlier, on behalf of this classics graduate student who was in a coercive sexual relationship with a male classicist, famous classicist, 50 years her senior. And as a result of, we wound up trying to settle it pre-suit. We were unsuccessful. We wound up filing the case. When we filed the case, we wound up getting 6 affidavits from professors around the country in classics who had been graduate students at Columbia during the past 50 years, where they said in detailed declarations signed that they experienced something very similar to what our client experienced. And once we were able to generate that body of evidence amassed over 50 years of bad behavior, where Columbia was put on notice and did nothing about it during that time. Columbia finally acted by firing the professor in question and entering into a settlement with our client. That settlement is public. That settlement, the terms of that settlement are not subject to a confidentiality agreement, except with respect to the amount of money she received. I can say that that amount was substantial. But I can also say that the other terms were important to her not to be confidential. And Columbia, to its credit, agreed not to mandate that that be subject to, the other terms be subject to a non-disclosure agreement. But generally speaking, defendants are very sensitive to that, and they really want everything to be confidential. So much so, we're now getting deals, or now having negotiations with the other side, where they say, we don't even want you to say the case has been settled, because that suggests something that we don't want suggested. So we only want you to say no comment. And so, you know, this is where we've gone. This is how bad it is. And it shows you how sensitive they are, which is a good thing that they're that sensitive, because that sensitivity should translate into changes going forward, because, again, they don't want to see themselves on the front page of the New York Times.
Do you think that social media is changing that? I mean, I think one of the astonishing success stories in the last couple of years is Susan Fowler's blog post about Uber. I mean, when she had an unresponsive HR department, she didn't even try with a legal remedy. She just posted it, and it went viral, and one thing led to another, and eventually Eric Holder did the investigation, and the careers of 20 executives were toppled as a result of that blog post. Are we seeing any of that in the legal profession?
I haven't seen that as an issue come up in any of our cases, and I'm not aware of it, although I'm sure it has come up, and I'm sure it will come up. We're dealing with some of that in the context of some of our academic cases, where people write blog posts or posting things on social media more generally, which sometimes complicates our efforts and sometimes enhances settlement. It really depends on the circumstance. So it's not necessarily a bad thing, but it can certainly be a complicating factor in settlement. Yeah.
Can you talk about your professional and personal opinions of your opposing counsel, and whether or not you feel what they do in defending these practices is ever defensible?
So that's a good question. Let me see. There are a lot of good people on the other side who work very hard and do the best they can for their clients. And they're very smart, and they're good adversaries, and I respect them, and I think they respect us. And I think that type of relationship broadly characterizes my relationship with defense counsel. There are exceptions, and those exceptions involve people who are demeaning to our clients, who are unduly aggressive in depositions or a trial, are sarcastic, say things that they shouldn't say, and do things that they shouldn't do. And you fight that. I have private conversations with people on the other side, and I say, what you did or what you said was really uncalled for, unprofessional, and borderline unethical. And I've never gotten to the point where I've had to raise an ethics complaint with opposing counsel. I've never had an ethics complaint raised against me. But I've been pretty close to doing that from time to time. And it makes the practice of law more difficult and disappointing than it needs to be. But you're going to get jerks in any profession. And the legal profession has its share of jerks. But I can say that, fortunately, at least in my experience, the firms that we sue or the business entities that we sue hire really good firms. The firms that we go up against are firms like Morgan Lewis, Jackson Lewis, Jones Day, Littler Mendelson, and those are all good firms, and they're aggressive firms, and they have really good lawyers and smart lawyers, and by and large, those lawyers do a good job for their clients and don't cross the line. Yeah.
I was just wondering to what extent you've had potential clients approach you regarding either workplace discrimination or workplace harassment. They don't have evidence of, let's say, a pay gap, and how you evaluate, based on what they tell you, how do you evaluate whether to get engaged, whether to take the client, and particularly regarding clients who either now, because of consumer social media, things that have happened in the past, they didn't necessarily think would
So that's a great question, and I'm gonna punt it to Cody, because Cody has handled hundreds of intakes during his time with the firm, and he did really an outstanding job in doing extensive write-ups and making really sophisticated recommendations based on his own analysis. So I'll answer your question, but I'm curious to hear what Cody says.
My experience is that it's a function of a lot of different factors. There's the question about, so you're saying, like, what if there's no proof? They don't have, in most cases, someone comes to you and they have a suspicion or there's been a pattern of behavior that they've seen that there might be a pay gap. But usually people don't have access to those kinds of records. Often it'll be through some sort of hearsay, like they'll hear from a friend, maybe a friend who's in a management position that they're underpaid relative to someone else. So my experience is that you sort of weigh that evidence and you weigh it in connection with the value of someone's claim, whether it's worth it for them to try to bring it forward, and you lay all that out on the table and decide if it's worth going after. And it's taking a case isn't just an on or off switch that you take it or you don't take it. Sometimes you go through various games, right? So you might not be something that you're ultimately going to file, but then you think that maybe you could take an argument for that maybe far enough to get the client. But
Yeah.
we left that to the attorneys.
Yeah. So no, that's absolutely right. There are a lot of cases where we don't have the evidence. We always ask for evidence, right? So we want documents. We want to see their pay stubs. We want to verify what it is they've made in the last year. We want a list of witnesses who might be able to corroborate the pay gap or whatever it is at issue. We make an evaluation of the person, himself or herself. Cody and the legal assistants would do that for us in the first round. Sometimes I'd follow up, or another lawyer would follow up and ask further questions and make their own credibility determinations on the phone. And based on whatever evidence there is, coupled with the credibility determinations made, coupled with the strength of the claims, coupled with the jurisdiction involved. If someone calls us from Idaho who has an individual case talking about a pay gap of 50 cents an hour, we're not going to take that case, and so that's an easy one. But if someone calls us from where we're located, or if someone calls us outside of where we're located, we have 6 cities, but if they're outside of where we're located, but they have a systemic problem that they think exists, as was the case in the Qualcomm matter, where we had an entire class of people who were underpaid, engineers at Qualcomm, then we'll be more interested in following up. But typically, what we do is we don't represent someone for purposes of filing. In fact, 99% or more of the cases, we send out a representation letter that just commits us to a pre-suit investigation, which buys us more time. So we send a letter, we may involve in negotiations with the other side, but during that period of time, between the time we send the letter and the time we actually get to mediation, we'll know a lot more. We'll have a lot more information at the mediation. And if the mediation fails, we'll be in a much better position to determine whether or not to take that case. But it would be very unusual for us to take a case based on a phone intake. By that I mean very unusual for us to file a case based on a phone intake. Yeah.
What strategic considerations go into having a military bring a discrimination case, and what especially
So it's very important, if you're talking about the gender composition and the race composition or the ethnicity composition of our trial team, it's extremely important to me to have a diverse trial team. We always do. And it's always interesting to me to see defense counsel, because defense counsel typically are all white. And our staff typically is not all white and is not all male. In the case that we brought recently, we had a majority of females on the trial team. And we always try to get ethnic diversity and racial diversity as well, depending on where the case is and what lawyers' availability may be at any given time. But we had an African-American male partner help try the case, and 4 out of our 6 lawyers were women in the recent case against Columbia. Yeah.
How do you go about ensuring that a firm is implementing equitable standards for their partnership selection? So what constitutes equity in that context? Is it 3 out of 15 partners? Is it half? Is it a majority? What constitutes equity in that context? And then I guess the second prong to that would be how that standard would factor in people who do not identify as women and people who are maybe trans or genderqueer or non-binary, and what those standards might look like as well.
So there are a couple questions, right? What are the equitable considerations from associate to partner? What are the equitable considerations from non-equity to equity, right? And those are different, presumably, within firms. From the associate level to the, say, non-equity level, you're probably looking at, all the factors that firms typically look at objectively, right? You're looking at billable hours. You're looking at origination, whether the person has originated cases or is or has clients that that person's responsible for, has done a great job in writing or oral advocacy. All of those reviews that come in, they pull together. Beyond that, you have, I think, what you're considering equitable considerations, the considerations that arise outside of that context. And I think your question is also, what do firms do, or what should firms do? What should firms do? That's a very difficult question. I think what firms should do, not from a legal perspective necessarily, but from a moral perspective, is to diversify their workforce. I think it's in their advantage, self-interested advantage, short and long term, to diversify a workforce. But there are limits to that. I had a conversation with my brother-in-law 2 nights ago, and he teaches law at LSU. And he was talking about 2 candidates, and he's on the committee, 2 candidates who are applying for a position there now. And one candidate is diverse and one candidate isn't. The candidate who is not diverse has an extraordinary record of accomplishment in publications in major journals. The diverse candidate does not have that. They can hire one person, and it's pretty much coming down to, I believe, those two people. Question is what to do, right? And that, you know, I don't have an easy answer to that. I think it really does depend on a case-by-case basis. But let's just say we had a very spirited debate about that very question. And I think a lot depends on, if you're talking about a law firm, a lot depends on your current composition, right? If you do have a diverse workforce or not. And if you don't, I think the onus is on you to try harder. And trying harder means to raise those equitable considerations higher than they might otherwise be. If you already have a full-blown diverse workforce, maybe those equitable considerations aren't given as much prominence. So I think it really is situational, right? Yeah.
I was wondering if you could reflect a little bit on the rise of forced arbitration, both in terms of how it's changed your practice and how it's impacted female employees' ability to.
Forced arbitration is a disaster in this country. The idea that we're having this conversation in 2018, where if you want to bring a case relying on your statutory protections and you want a trial before people in the community, and the idea that you have to sign away that right and agree to a private proceeding, which is often greatly stacked against you for a variety of economic reasons, thereby diminishing the prospect of being successful in an already very difficult road. Even if, look, if you go to court, it's not easy. All the people who rail against, you know, our system of justice and trials and who are proponents of tort reform, you know, don't fully appreciate how difficult it is to be successful or aren't sufficiently empathetic in their views. You know, I can't help but remember Judge Bork, who railed against tort reform. Until, that is, he went to Yale Law School to give a talk, and on his way up to the podium, slipped and fell and broke his ankle. And what do you think Judge Bork wanted to do? He sued for a lot of money. And all the, you know, talk about tort reform went out the window when his ankle was at stake. So I just think that, you know, people have a jaundiced view about this, a very narrow view, and it really has impacted people's ability to be successful in this process or just to get a fair hearing. And it's not only forced arbitration, it's forced arbitration combined with class action waivers, which is really a big problem because if you're a consumer and you're getting ripped off to the tune of $5 a month, you're probably not going to bring that suit on behalf of yourself. But you may be inclined to bring it if it's important to you to change that practice. So, you know, the only way, again, we're going to change the law with respect to arbitration is not at the Supreme Court. That's pretty much settled right now, and it's going to get worse in the years to come. The only way to change it is to change Congress. Yeah.
What more should be done at the law school education level?
I think that, you know, I gave a talk at the Harvard Law School last year, and there was a lot of talk about arbitration. And I suggested to the students there that they band together, sign a petition, and make it clear to the administration that they do not want big law firms coming onto campus who insist on arbitration provisions. And to my knowledge, that's what Harvard students did. I don't know what the result of that has been. It's only been, I don't know, 6 or 8 months since I was there. But I think that's a start. And I would encourage Stanford Law students to do the same thing. If I were a Stanford Law student, I would not want to be in line for a big firm, plum summer associate position and the possibility of an associate's position if that firm insisted that I sign away my rights. Yeah.
With the rise of the family leave campaign, have you seen any changes at the employer level in terms of the way discrimination is going for pregnant women or women who might become pregnant?
You know, I don't have an opinion on that, and haven't viewed that one way or another. I can tell you that I was as shocked as I can be, and it takes a lot to shock me because I've seen a lot in my legal career. But I was as shocked as I could be when I saw what happened to female associates at Morrison and Foster. I don't mean to pick on MoFo. As I said earlier, I think it's a great firm with a proud tradition, but it's got a big problem. And the idea that it would, as a matter of practice, hold women back for availing themselves of statutorily protected leave is not only a per se violation, it's an outrage. And I think that if it happens at MoFo, then MoFo probably isn't alone, and the problems are likely to be more widespread than I realize. So I would say that, but I haven't seen a lot more of that. Yeah.
I'm curious about how you deal with partnership points and some arguments along the line of this is not the firm's problem, this is a market problem where male partners are bringing in more business because male CEOs or more partners, et cetera, so you're only slightly pride in the market that female partners are sort of. How do you deal with those arguments?
So the question is, it's a great question, there's so many assumptions built in there. But one issue is, how is it that business is generated to begin with? And firms typically support business generation in a variety of ways. So they'll send people to conferences and they'll put people on panels and support them in the community, in the business community. And the question then is, how do they do that? And whether they do that fairly as between men and women. The experience that I have in the law firms that I've looked at is that women are disfavored in that process. So it might be true that men originate more, but the question is what's responsible for that origination and how much support does the firm give? Secondly, there's always a debate in firms as to whether or not a certain person actually originated the case. That's what virtually every case we litigate is partly about. The conflict between men and women about the origination assignment. That assignment is made typically in secret, typically through complete discretion, and often arbitrarily, where a man can get full credit or near full credit for something that a woman should at least get partial credit for, if not that much credit that the man is getting. And so there are debates about that. And typically what we see is that women have an opportunity to challenge those origination credits, but the people they challenge them to are the very people who make the initial decision, and it's rarely changed. So we're fighting at that level as well. So it's complicated. I think you're right in the ideal world. If it were clear that men originated more and we're just talking about a business decision to assign more points to people who really originate cases, absolutely, I'd agree with you. And if it just turned out that women maxed out at 1,000 points and men maxed out at 2,250, so be it. I don't think that has to be equalized. But you have all these other issues that once you unpack, you realize there are serious problems. Yeah.
Do you think that you should be kind of the model of gender equity, and also how your firm dealing with that? I guess the number of partners that you have.
So we have a firm that it has a majority of its lawyers female. We have a firm with a majority of the legal assistants female. We're very proud of that history and tradition, which we've had from the beginning. We have a firm that is diverse racially. We're the only firm in the United States ever to have 3 African-American partners head up a fraud section, let alone 1. I'm not sure there's ever been a firm that has 1 African-American partner head up a fraud section. I'm not aware of it. I doubt seriously there is a firm that has 2, and we have 3. So we've done a lot. We hire LGBTQ applicants on a regular basis, as we just did recently with a guy who graduated from Yale a year ago and has clerked for the last year and was head of the outlaw program at Yale. We hired recently a woman who's trans in our DC office. And so, yeah, we're proud of that history. Can we do better? Absolutely. We're not perfect. And I'm sure there are things we can do more of that we don't do. But I'd be very happy to put our firm up against any other firm in America on the diversity scale. Yeah.
I have a question on job assignment. If a client asked a law firm to staff its matter with, say, 50% female associates or 50% associates of color, and the law firm then made that job assignment, could that possibly generate Title VII liability for the law firm? And is this something that law firms are worried about in your experience?
I don't know if law firms are worried about that. I'm not sure it would generate much of a case if that were, if it were what you just said. I think it could generate a case if the hypothetical were different. If a client came in and said, I just want males or I just want whites on my team, that could generate a case. But the hypothetical you gave was 50-50. I don't see that being a problem at all, and I don't think firms would worry about that. I have heard of situations in large firms where clients have a clear preference for whites and have expressed that preference, and that's led to issues involving me. But generally speaking, given the hypothetical you raised, I don't see a problem.
If I could follow up.
Yeah.
So it was 75% female, and this client was generating fewer billable hours. So there was some adverse impact on the female associates. Would we be getting into maybe trouble there?
I think you'd be getting into the kind of equitable considerations we talked about earlier, where, at the end of the year, if the firm decided to honor the client's wishes and it turned out that had negative impact with respect to billable hours on women, then I think that would be an equitable consideration a firm would, out of fairness, have to deal with, right? But again, other than that, I don't really see there being a problem.
Can I ask one, David, I always ask people to give the lectures as part of this leadership series. If there are any sort of major decisions you would make differently in retrospect, anything that, not a happy story and caused you to rethink some of the way that you approached either a litigation decision or a decision as a managing partner?
Are you talking about case-related or firm management-related?
Just, leadership failures. I'll just put it down. Or challenges. Let's say challenges. That's better.
That's a great question. And I'm probably not self-reflective enough to be able to come up with something on the spot to answer. But I will say, getting back to this gentleman's question, I do think that there's always more we can do. As a firm, with respect to our hiring, we have almost 50 lawyers now, and we have almost 40 legal assistants. So the hiring challenges are great and constant. And we have tremendous people applying all the time and sifting through. I met with a guy last night in our San Francisco office, and so I'll tell the story, and I'll ask you if I'm failing in some way. I met with a guy who drove up from LA, and I won't talk about any identifying information, but he is a diverse candidate. He's senior. He's been in the profession for about 15 years. He has worked at two very well-known defense corporate law firms. He also worked at GE Capital for a couple of years. And he wants to make the shift from corporate law to what we do. And I asked him in the interview, what social justice commitments he evidenced in his life, because I was not aware of it. I said, we hire people at the legal assistant level and at the lawyer level who are excellent academically, who have distinguished themselves academically, but who also have evidenced something in their lives through their writing, through their work, through their experience, that shows a commitment to social justice. And it doesn't have to be social justice narrowly defined, but it has to be something. Because we're not interested in just taking the next 4.0 from Stanford, who has worked and done nothing else. And I'll just say he didn't give a great response. He's been locked in this corporate world. He talked about one pro bono project he had worked on years before, but he didn't have a great response. So then I tried to elicit more. I said, look,
from a personal level. I was trying to get to the personal. I said, look, when I was growing up in New Jersey, I was 6 years old. I was walking on the beach with my parents, and there was a sign that says, and I'll never forget it, no Jews, no blacks, no dogs allowed. And I'm Jewish. And my parents and I stood there, and we talked about that moment, you know, what it meant and what we should do and what the law was and so on. And it's seared in my brain, that moment, forever. And I think, you know, that moment really, in part, defined who I am and what I've done and what my commitments are. And so I told him that story. But in response to that story, he didn't really give anything that suggested he has a story. He said something, which I won't get into because, again, I don't want to give any identifying information, but he told something. But when he left, I met with a few of the lawyers in our firm, and I said, we're not going to hire him. And we're not going to hire him because he doesn't have that passion. He doesn't have that commitment, which I think is really necessary to do our work well and to make the sacrifices that are needed to be made in order to do this well. And I thought about that whole experience last night as I went to sleep, and I thought, you know, am I missing something? Should I have asked different questions? Am I being too hard on this person? So I'll throw it back to you. Am I missing something? I mean, do you think I should be asking different kinds of questions, or does that represent a failure on my part? Tell me why. No, because if you think so, I'd love to hear it.
Well, if that's the worst they've got on you, David, you know, I think you're going to be okay. I guess my own sense is that having placed two of my former students at your firm, happily so, both of whom had, you know, well-documented social justice commitments, I think there's probably a failure there, and maybe a failure on the part of the law school that person went to. I mean, almost everybody at this law school now could give an answer to that question. I mean, the number of students here who are involved in formal pro bono projects or informal social justice commitments, you know, we're close to 100%. And if we don't get to 100%, I think we failed as a law school. So yes, I think that's absolutely the right question. And honestly, I wish people who are not just in your kind of work were asking that question as well. And maybe that's a good note on which to. You have one more? Yeah.
Hi.
Hi.
I just wanted to say that I think that it's great that you're curious about people's social justice initiatives, but where I see maybe there might have been a failure there is that it could have just been that because of the pressure of being the first associate at a law firm, he felt extremely pressured to continue to do work that was bringing money to his firms and didn't have time to do the pro bono because the diverse associate doing the pro bono looks different than the non-diverse associate doing the pro bono.
Right.
And I also
Right.
think it's really weird to put someone in the spot in the middle of a conversation and have them have to like proclaim that they actually do care about those issues, especially if there's things personal in their life that they might not want to share with a stranger.
Right.
But other than that, I think it is good to.
Well, let me push back a little bit. I hear what you're saying, and I thank you for your candor. But let me be equally candid. We have a law firm of people who are extraordinarily committed to what we do. And as I was saying to Professor Rohde, to do what we do well, I believe, I could be wrong, but I believe, in my experience in being chairman of this firm since 2004 and a managing partner for many years of another firm prior to that, another civil rights firm, suggests to me that to do this at the highest level requires extreme intelligence and extreme commitment. And yes, it's true that this person may have a story to be told about why he did what he did in the corporate world for the last 15 years. And that story can be perfectly understandable and legitimate and sympathetic. But the reality is, he is who he is. He is where he is now. He's not 3 years out. If you tell that story 3 years out, you get a pass. You don't get a pass from me if you tell that story 15 years out, because that's too much time to do something in your life that really matters beyond billing at a big corporate law firm. That's how I view the world. Not everyone shares my commitments, and not everyone would share that view. But that's my view, and that's how I've defined this firm. And so for me, in pushing back against what you said, for me, it does matter. It does make a difference. And so there's little leeway there. He could have told a different story, and he could have been a sympathetic story to me. He didn't tell that story, and therefore he wouldn't be hired.
God bless you. Thank you.
Thank you.